on page 21, and its type copy is page 20. It was the stone that was transported was from Sonbhadra to Siddharth Nagar. Distance is also
Page 20.
page 20 is the type copy. And next page is the original one where it has been checked back at the check post. The stamp, it bears the stamp.
It also admits that this is genuine.
And the police also admits that this is the genuine one. Only the forged one on which it was the driver took my name, that since I'm a truck owner, the dates were changed. My lord, may kindly say 15, 16, the distance is 357 kilometers. And obviously while coming back, he has played some mischief. And my lord, I'm a regular, I'm an income tax payer, and I filed an IOWare, several such e-challans have been filed, which have been checked properly.
It's possible for what your driver doing. You are the owner.
But look, someone, because the time gap between these two.
You are showing at page 20 P2.
My lords, and the original one is that.
Valid permit.
Yes.
For carrying the minerals.
Yes.
Expected minerals on 15th and 16th August.
Correct.
Yes. And you are caught when?
Yes, they according to police, next day, 17.
So therefore, you are using an old permit. That must be the 17th.
I'm ready to cooperate. And offenses, all the mines and minerals are to be cognizance is to be taken on a complaint case. Now I will keep a check on the drivers, so install GPS or whatever it is, so that and the offenses, all the offenses are less than 7 years punishable.
While arrest of the petitioner shall remain still, subject to his joining and fully cooperating with the ongoing investigation.
We will cooperate.
He appears to be in a bit, because earlier also there is one more case.
My lord, that was not my truck. Yes.
Anticipatory, so is emboldened. Now, truck you yourself will not drive, you will keep a driver. And after time you say, my driver has done it.
No, my lord, I will not do that. Truck has already been seized. It's in line with the police. I've suffered enough. So, no coercive, my lords. I'm grateful to your lordship, my lords.
Lordship, I am in custody since 10th of June 2021. Lordship, High Court has dismissed my bail application on.
But what to do?
Yes, Lordship.
For a hardened criminal.
Lordship, but this court itself has done that in the particular matter, the court has to consider the only case. And this case is only. Lordship, in the Prabhakar Tripathi, it was held that the court has to consider this case only. And in this case, Lordship, the complainant is the.
Every time the court must certify that how many offences you keep on committing.
Lordship,
while on bail.
Lordship, he is on bail in each and every case except the present one, and one more case is pending.
Therefore, there is a misuse of concession of bail.
Lordship, but the thing is that in this case.
Misuse of concession of bail. You get the bail.
Yes,
come
yes,
out, commit another offense.
Lordship, but on that particular date, that the complainant himself was in the influence of liquor. He has outrated the modesty of the mother of the accused. And even if Lordship may see the photographs, the complainant is having axe in his hand and he's knocking on the
302 to 397, 392. Where is the list of the cases against you?
Lordship, I have annexed that. I think in that. But he is in bail on each and every case, Lordship, except the present one.
While you are on bail in a murder case,
Lordship,
registered against you in 2019,
Lordship,
you are committing all these offenses.
Lordship, then see the photographs which I annexed. It is part of this. The complainant himself. And Lordship, just allow me to read Annexure P6. What is the observation of learned trial court? If Lordship may permit me, I will read it. P2, page 28.
Forget about trial court observation. The High Court has taken note of everything. High Court is aware of this principle.
Yes.
High Court says in this very case,
yes, Lord.
if you are granted interim bail,
Lordship,
you comes and commit another offense also under the Arms Act.
Lordship, it was.
You have so much impulsive to commit crime. What can be done? You are
Lordship, it is basically entirely civil dispute, Lordship. He is the real uncle of the. Lordship, permit me to read.
17. that he granted and then for one.
Lordship, three witnesses have been examined. The main witness, that is the complainant, and his wife has been examined.
And how many are left?
Lordship, around 11 or 12 witnesses more.
So we will direct that in case trial is concluded within 6 months, fine. Otherwise, we will grant you liberty to move again.
Lordship, just read page number 66. Just read with the observation of the London Trial Court. What?
Don't go with the observation of the trial court. We are
Lordship, the trial court itself is saying there should be a cross case. It is entirely civil dispute. Even the I have announced that
Your conduct, which is recorded in para 70.
I agree with my content, but this case has to be considered. It is basically, Lordship, and there is widow mother and old age grandfather. Of
you are caught in CCTV camera where you are firing with an
Lordship, in CCTV camera.
unlicensed pistol or revolver, whatever you are carrying. You are caught on CCTV camera because otherwise you are denying. But then when you knew it that now you have been caught on camera, so therefore you can't.
Lordship, it
Now
was
you are
in.
telling a story that he tried to.
Lordship, I'm not building the stories. Even CCTV footage.
If at all somebody dare to do that, you should have taken. You can't take the law in your hand. You should have reported the matter.
Lordship,
Even
we have filed, but it has been
consequences.
registered as NCR only. Lordship, just observation of the trial court need to be considered once. Lordship, page 66, last paragraph. Lordship.
We direct the trial court to conclude within 6 months. If they don't do it, then you move on application.
Lordship,
Having heard and consent from the petitioner, that you consider length, we are not inclined to release you on bail at this stage. Also, when the prosecution witness as evidence has already commenced. Into consideration the fact that case came to be registered in the year 2021. We direct the trial court to make an endeavor to conclude the trial within 6 months, subject to the cooperation. 6 months, instead the petitioner, from his counsel as well as the public prosecutor are directed to extend full cooperation to the trial court to conclude for conclusion of the trial in the time-bound manner. Instead, however, if the trial is not concluded, it is stipulated here for some unforeseen reason. Liberty is granted to the petitioner to renew his prayer for bail. Please have this assisted.
Lordship, more directly that trial could decide the case on his own merits. Trial court shall decide the case in its own merits without any prejudice with this order. Yes, Lordship.
Goes without saying that the trial court shall not be influenced by the observations made by the High Court in the interim order while deciding the main case on merits.
Please. Like this is the Tamil Nadu ED officer's case, Your Lordship. I've moved a small modification.
You are allowed to visit this case.
Lord, I have no difficulty. My lords, in the order itself has granted liberty to visit. He could have moved the trial court, my lord, to get the permission. I don't know. Till Diwali, let him go. Let these matters may be listed, my lord, for hearing because that issue needs to be decided. I have no difficulty.
That of course decided.
Lordship had imposed a condition that with
We are only concerned with this minor issue.
So, Lord, let him visit. I have no difficulty. He may go and visit.
Applicant frequent authorized and same consequently. State. Committee undertakes 20th March 2024. Modified stroke clarified. To the extent that each is permitted to visit.
Lord, it should not be Madhya Pradesh. It should be either Bhopal or Sanchi where his wife is posted. It should be a specific place, Lord. It can't.
may make it Bhopal.
Bhopal, maybe Bhopal.
But where is the problem of Madhya Pradesh?
Lord,
Suppose his in-laws are there at some other place, the sister is other place, he can go there, what is the problem? In Madhya
Lord,
Pradesh.
in application, he has prayed for only 2 places. That is why I said.
So like, well,
in application.
Why he has gone to Bhopal via Suvarnasuri?
No, I am, no one is saying that, no. I would have otherwise opposed this application.
How does it Bhopal or Indore, how does it happen?
Because he has come out with a specific case for those two places. I was.
Madhya Pradesh. It's probably numbers. Slow for relatives. What is the next date in trial court?
My lord, he state the,
But there must be given some date.
no date was given. It was the investigation. We were about to file charge sheet when my lord is state that proceedings. We couldn't file charge sheet. So there is no proceeding for the trial court.
So how is there any date fixed by the trial court after 9th of November? How are the petitions remain present before the trial court?
Deeply. Deeply.
And main case supposed to matter for everyone's also there.
Deeply.
Great.
Please, madam.
Lordship, there are three connected cases. I'm only concerned with the application, but your lordships are posting the matter. There's one case by the ED against Tamil Nadu, and there are two
Yes.
cases. So all those three cases may come up.
Those have nothing to do with those cases.
Certainly.
This IAS one suspense.
Certainly.
Deeply.
Please, madam. My lords, in this matter, my lords, the learned single judge had decided the writ petition in my favor and had dismissed the writ petition. And my lords, in appeal, respondent. My case is completely covered. Let's be as well.
Notice, she notice regarding the Lord's answer here. Meanwhile, official law. That's the agreement of the High Court. In LPM number 534 of 2022, so in state.
Obliged. My lord, delay in refiling may kindly conclude. Obliged, my lord.
May it please, my lord. Lordships, in this matter, this is the Bihar Panchayati Raj matter, Lordships. We are here for the Pramukh who's. Yes, Lordships. Lordships, in this case, in fact, there was no challenge to the first motion. And that first motion failed and the applicant before my lord, she was successful. Now, Lordships.
Notice.
Lordships. Lordships, in fact.
Now, what is the problem here?
Lordships, in fact, Lordships, now a notice has been served.
No confidence motion.
Yes, Lordships. On 19th, Lordships, on 19th October, that has been served, Lordships. The notice has come on 19th October. And it is for 28th October. Therefore, Lordships, we were traveling. In fact, that first motion took place in January, not challenged, Lordships. Deeply obliged.
No, this is the second no confidence motion moved against the petition shall be taken in the meeting scheduled to be held on
28th.
October 24 or any such or the meeting or any meeting that will fix thereafter.
Deeply obliged. Lordships, one small request. Lordships, the some of the respondents in the main petition, those two orders challenged, the pro forma parties, they may be deleted for service purposes, Lordships. Lordships, it is respondent number 6 to 27 in the first impugned order and 8 to 48 in the second impugned order. Lordships have been pleased to pass similar orders.
We don't know.
Private
petition-
reporter.
what's the petitions that they run through and what's the petitioners do that
Private reporter.
as per the instructions. So also respondents are performed only.
Lordships.
C6, the service of these respondents is going to discuss with that there is some responsibility.
Lordships. Most grateful. 6 to 27 in the first. Lordships, I'll give in writing. Lordship, there was no High Court proceedings in this matter. Grateful, Lordships. Most grateful.
Only notice, that won't even. There is no delay as far as 24 full bench is concerned.
No, Lordships. Most grateful, Lordships.
Lordship. Here, Lordship, on Honorable High Court, the election tribunal allowed the election petition and directed the recounting. I think, and the Honorable High Court even this case came up to this Honorable Court at the instance of respondent number 1. Your Lordship dismissed their petition. And final order, recounting was done. In recounting, the petitioner herein secured the highest votes. Now he was declared winner. And the High Court set aside, saying that the election tribunal doesn't have jurisdiction. Lordship, this
No, but just see, this order passed by this election tribunal, what a funny order has been passed. How can this order sustain?
Lordship, please kindly see.
This order is reproduced page 6 by the High Court.
Lordship, page 6 by the High Court. Yes, Lordship, page 6.
See, what is the reason, single reason assigned in the order?
Lordship, that order is operative portion of the order. Lordship, entire order is here. Lordship, kindly see. Now, page, original order is at page,
Original order.
Lordship, page 116, T10. Now see, issue was framed at page 125. Issues were framed by the election tribunal. 125. And thereafter, the election tribunal decided and hold, finally, Lordship, kindly have the finding page 133. Even the counting agent of the petitioner was removed, was arrested from there. Lordship, 133, para 2, based on the above consideration. A detailed order, Lordship, has been passed by the election tribunal. And thereafter directed the recounting should be done 134 on 23rd of September 2024 on Monday in the
You are making all these allegations against the lady. How could she hijack or
Lordship members, Lordship, everybody was there. Even the statement was recorded. Everything was done. It is not that the election tribunal has passed just a cursory order. Entire evidence was considered. Both parties laid the evidence. Thereafter, election tribunal decided it. And Lordship, this case is entirely covered by the order, similar order passed by your Lordship, arising out from the order passed by the Chhattisgarh High Court at page 1, Lordship, kindly see, 158.
that every case has its own facts. What
This-
are you referring?
Lordship, this case also, the election tribunal considered entire evidence. Even the statement of both witnesses were produced, recorded, and thereafter the election tribunal came to the finding that this is well-reasoned order, Lordship. And the High Court just producing one paragraph that this is the order passed by the election tribunal. The High Court has not put the reasonings given by the election tribunal in the impugned order. Lordship, kindly have. And 2 times, even the High Court directed the election tribunal to decide in 6 months. Earlier, the respondent number 1 was delaying the matter. Again, they filed a writ petition in the High Court. Against that order, they came here. And your Lordship dismissed their petition. A recounting was done on 23rd. It was informed.
Their SLP was this Lady Kehkashan's SLP.
Yes.
8690/2023. That
Yes.
was dismissed against which order?
Lordship, kindly have this order. Lordship, kindly have this order. This is the order since they were challenging. They filed a writ petition saying that they have not annexed the challan with the election petition.
No. Which order of the High Court was
Lordship,
challenged in the SLP?
Lordship, this is the order. Lordship, that order was not initially with us. This is the order. Lordship. Lordship.